first such study, as I understand it, to examine through qualitative work the experience of women asylum seekers, the impact on them of the appeals process, and some of the factors at least underlining their successful appeals, plus whether this joint presidential guidance note of 2010 is being implemented, and if so, how. And I was sorry to learn that we still have some judges saying, I don't bother to look at it, it's just common sense.
The first thing I think that really ought to be highlighted is that very significant data that shows that women's cases are more successful than men's cases. And that is important, and I think it's worth debating why that.
I really applaud the hard work of the researchers. They've done a marvelous job. And from the findings of their research, I would say that they did a thorough job.
So I want to move on to talk about the sort of purpose of this report, what led to it, why did we decide that this aspect of women's progress through the appeals process was interesting to study. And there's two areas. The first is that we published a report in 2011 called Unsustainable, and it looked at the quality of initial decision making in women's asylum claims. One of the things that it led to, having done that research, was we actually persuaded the Home Office to develop a whole training module on women's asylum issues and gender issues for their caseworkers. So we felt that was a very positive response. And the other thing we found, and this was totally unexpected, was that a woman was more likely to have her asylum refusal overturned on appeal than a man. So there was this disproportionate aspect that women were more likely to get to have a successful appeal than men. And we were really intrigued by that differential and wanted to investigate more why that should be. The other thing that we were really interested in was what was going on in relation to the Asylum Gender Guidelines. So what you can see are the Asylum Gender Guidelines, which Katrina Jarvis, who's one of our expert panel, co-wrote, and which were in place with the tribunal between 2000 and 2006. And once they're gone, we were concerned that those sort of guidance, which focuses on issues that particularly affect women seeking asylum when they go to appeals, had been lost. But then in 2010, the President of the Tribunals published a practice direction and a supporting guidance note on children and vulnerable witnesses. And that was really supposed to bring in some of the issues that would particularly affect women. And we were intrigued by that because we wanted to know, do people use this guidance? Is it effective? Are there any things missing from it that maybe were in the original Asylum Gender Guidelines? And so that also formed part of our research. So that's what we've been working on, looking at how the asylum appeals process works from the point of view of women themselves and legal representatives and judges. And we're really pleased that today we're going to be able to present those, the emerging findings and recommendations, and have the opportunity to discuss them with you.
Under this broad aim, we wanted to find out, how do women asylum seekers experience the appeals process? What are the range of ways the appeals process impacts on women's asylum seekers? What are the factors underpinning women's asylum claims being successful on appeal? And lastly, how is the joint presidential guidance note being implemented in relation to women's cases? And the aim of the interviews was to really gain a real in-depth understanding of women's experiences of the process. So that included an understanding of the legal mechanics of the asylum appeals process, the extent to which they had an active role in their hearing, how information was communicated to them, the nature of the support they received, and a reflection of the impacts and experiences of going through such a process. A second key aspect was how much the legal representatives and interpreters and legal roles enabled women to play their own appropriate role in the hearing, so maybe to take more of an active role in the hearing itself. There are examples of where this was so and where women had played an active role, but there were examples where this was less so, and women on reflection would have liked more opportunity to contribute to the hearing. Or they would have liked the opportunity to speak directly to the judge or clarify parts of the hearings. Thirdly, how they felt the case had been represented. So obviously providing an accurate and insightful representation of the case was really felt to be a key part of their roles. And so for the judiciary, this, as probably would be expected, also involved them displaying signs of impartiality. Lastly, the approach and manner was highlighted as an important aspect. So women welcomed an approach that was sympathetic and accommodating, and also when the people in the court conveyed a good understanding of their case and the context and backgrounds that they'd come to be there at that time.
Very encouraging to note the factors that both women and judges identified as best able to support a woman through the appeals process were very similar. And it's no surprise that women felt most enabled by being informed, being enabled to actively contribute to the process, as opposed to simply being told it'll all be all right, being reassured. And in terms of the judge introducing him or herself and others present and explaining procedure, this should happen in every case and not just in some. So again, I was sorry to hear about that, and again, refresher training indicated.
I've practiced for over 30 years, and it was a flash of lightning to me that appellants, clients think you're the boss, you're the judge, you're the lawyer, you're going to ask me the questions. So the person who does the running, they expect the lawyer to do the running. And that, I think it's very important that we say, is there something you want to tell me? Is there more to say? So we enable our clients.
I always used to say at the end of a witness's evidence, is there anything else you'd like me to know? And that very often did produce something very, very key that had been left out. And if the judge hasn't asked that at the end, then I think the lawyer can ask it. Obviously, having prepared the client in advance for it not being a presentation of everything that they want to say that hasn't been said, but tailoring that expectation.
The role of the legal representative was also crucial. Establishing that disclosure, obtaining that evidence, normally will not happen without a high-quality representative. Preparation beforehand, absolutely critical. And some legal reps said poor preparation can damage a case irreparably. In 4 of the cases, the woman had 2 first-tier tribunal hearings, which is quite unusual. The effect of that was that we could compare in the same case 2 sets of preparation. They were different in these respects, the quality and the volume of evidence, extremely different. And the level of involvement of the woman appellant in her case was also very different between the first rep and the second rep. The woman got status on the second hearing, but following the first hearing could easily have been removed from the country.
To put lawyers' preparation at the bottom of your list and to put judges, the importance of judges as the first priority, I think is the wrong way around. The absolutely critical thing is to have the case prepared properly. The most critical thing that lawyers can do is to take a good statement. If you could teach people as part of their legal training how to interview, how to prepare a statement, the sorts of things, you don't have the credibility problems.
It depends on who your legal representative is. If the woman is lucky to have a good legal representative, then most of the positives in Gina's paper and will happen.
Once it is written down, then there's a much smaller chance of you being questioned on it in the hearing, so that they are spared those sort of intrusive and personal and distressing questions at a hearing. Also for lawyers, because we spend an awful lot of time learning about the law, but very little time actually training us to deal with people. And if you don't have the confidence of someone, and if you can't develop some sort of decent empathic skills, then you're not going to be a particularly good first instance lawyer at any rate.
I would just caution about what you were saying about regulation. I think, to be honest with you, you'll have a lot of opposition from practitioners if you start talking about additional regulatory burdens, because people already feel quite over-regulated in terms of the accreditation scheme and so on. And I think it's good to promote best practice.
The action of the tribunal judge it's, to me, fundamental. Because the judge, the way the judge relates, it's not all of them, I must say, but, from experience, I can say that some of them are really, really good. They make you feel, they just put a human touch to it and make you feel valued, for whatever reason. And I think that is good practice, where a judge makes you feel comfortable and not allow aggressive questioning as well.
There was examples of some judges explaining what would happen at the beginning of the hearing, introducing themselves, introducing others in the room. But there were also examples of where this had less.
As a judge working on judgecraft training and the drafting of guidance to try to ensure that every judge approached every case before him or her with an open mind and assessed all the evidence in the round with care, using a recognised methodology in order to reach findings of fact and apply the law, so that we would have some consistency of approach to that evidential assessment and the assessment of credibility. So to learn now that still the same case can fare differently before a different judge or with a different lawyer is a factor of concern and importance, and that bears further investigation. And maybe it indicates refresher training could be a help all round for judges and lawyers alike.
I think all interviewees said gender-based violence is key to women's appeals. Many women's appeals involve gender-based violence. That has implications. It has implications for giving evidence, obtaining evidence and assessing evidence. For giving evidence, disclosure of what's happened may not be made initially, i.e. in the Home Office interview, possibly not even to the lawyer, possibly not even until the door of the courtroom. Some instances were given of that. Because people here will be very aware, it's very difficult to speak about gender-based violence. There are so many factors pushing against it for the individual. Shame, loyalty, threats, fear of the family, fear for the family, the repercussions, and in some cases not appreciating that the person's own experience actually founds an asylum claim in her own right.
My case is like FGM. My mother is doing it, and me, they did to me, age of 8 years. Okay, and I'm the first daughter to her. So I have to, and at the same time, forced marriage. Then when I came here, I never know in Africa that here is asylum. But the man I came with, I don't love him. It's forced marriage.
In our community, there are more than 200 women asylum seekers together who are facing the issues that we've discussed here. First of all, the anxiety on the first time, when you're going for your screening. You are not made comfortable, and you've never faced a male, a male interviewer or a male judge. You're used to a female one, and maybe your background is your domestic violence or FGM. You're not able to close because of your faith and your cultural background. You're not free to disclose, and you are failed by the Home Office because you've withheld the information. And that information comes to haunt you.
Something needs to happen to try to enable that disclosure. And one of the key things that legal representatives talked about was establishing trust early on in conditions of confidentiality and privacy and freedom from family interference. Where harm has occurred in the private sphere, say within the family, it may be much more difficult to get supporting evidence than when something has happened in a more public setting. There may be no physical signs sometimes. There may be severe psychological symptoms, but the cause of those psychological symptoms may be hard to identify. Expert evidence is key to overturning an asylum refusal on appeal. Medical experts, often country experts where the existing public information is not adequate. Assessing evidence in the case of gender-based violence. For judges to be educated and informed about the prevalence of gender-based violence, about the conditions for women in countries of origin, and the impact on the person of having gone through that experience, the effects of trauma on memory, the reasons for late disclosure, which we spoke about earlier, the effects of shame on giving testimony either in the moment or at an earlier stage, including in the Home Office interview.
When we come to this country, we come here for protection. When you go for your first interview, as my colleague said, that's where mess up will start. So from there, I was going to tribunal, which you are talking about, you can shiver. Yeah, I was one of them as well. When I go to tribunal there in Piccadilly, when I go there and find the judge who is in front of me, I said I'm going to stop the truth, but the truth was scratched out. I was just nominated from where I was sitting. She was shouting at me, "You are a liar."
Credibility assessment is the second factor underpinning the upholding of an appeal. In the files analysed, all the successful appeals were upheld on the basis of the judge's assessment of credibility. Therefore, the judge's assessment had differed from the Home Office assessment. You can see that. The centrality of credibility, therefore, comes out in this particular group of files. Where credibility was upheld, it was assessed in the round, dealing with the woman's testimony and medical evidence where that existed, country of origin information as a whole, putting all this together. So this is a quality of decision, of credibility assessment, that was noticeable in the positive decisions. And it could be distinguished from a speculative or itemised approach.
Women that are mostly doubted, with the moment they talk about sexual violence or domestic violence, then or anything, then they are doubted. But if a man claims that, there's something else, for some obvious reason, they are believed. Most people, like I know, once you see people come into the tribunal building, there's this thing about it there, everybody is so anxious. And you could see it on everybody. Some are like shaky. And this is fundamental. You can't get much of a good evidence from somebody that is so anxious.
If you can put yourself in the shoes of the person you're interviewing and anticipate the credibility problems that might come. Most of the time, credibility accusations come about because you've left something out of the statement.
And I think, a very important point is that if we collect the evidence appropriately and we think of it as an information gathering approach, and there are tools there and there are opportunities for people to receive training, then some of the credibility issues are not going to arise, and that system is available, and the research is there as well on how best to assess credibility.
So what about the guidance note in all this? Is it used? Is it useful? What's it doing? Could it be better? It was used by some legal representatives of those interviewed to make representations about the conduct of the hearing for a vulnerable appellant. So that's to put evidence at the beginning of the hearing to say this appellant is vulnerable and we should treat her accordingly, we should give breaks, proper breaks, make sure there's no hostile, aggressive questioning and so on. Sometimes it was used to request an all-women tribunal. There was a variation in the judges' uses. Some judges said, I don't really refer to it, I think it's common sense, it's good practice, but I don't actually look at it. Others said, I always have it to hand, I have it by me, it's a vital tool. What did legal representatives think about whether it should change? Some said it should be amended to give specific guidance on the conduct of women's appeals, because there are some elements there that you can see that are relevant, but they're not specific to women. Other legal reps said the judge's attitude is more fundamental than specific written guidance, so there's a variation of views there. The specific gaps in the guidance note. Going back to the 2000 guidelines that Deborah mentioned earlier, Section 5 of those guidelines talks about the process of appeals, of women's appeals, and good conduct of those appeals. And interestingly, a lot of the issues that came up in this research are actually dealt with in those guidelines, and here are some examples. And I've taken examples here of things that are specific gaps in the 2010 guidance note, not where there's an overlap. So the effect of shame in preventing early disclosure, the influence of male relatives, women not being aware that what has happened to them may found an asylum claim, the judge's conduct of the hearing in terms of understanding a traumatised individual and communicating well, and the relevance of previous bad experience in a Home Office interview to the appeal itself.
In relation to the guidance note, 2010, we're now in 2017, so I think it is a moment to revisit the guidance note.
I think the vulnerability guidelines are pretty poor, and they could be vastly improved. I think they've been written so as not to give way in a whole host of cases. But the really good guidelines that I think that we should be thinking about are the old bench books that were done for judges, particularly in the criminal jurisdiction, because where judges have difficulty, and I think where Home Office people have difficulty, is the understanding some of the cultural things that are embedded in gender persecution.
Some women need an all-female tribunal in order to be able to give evidence in some cases.
Other factors which could impact on women's experiences of the hearing included the gender of the court. So for some, the actual gender of people in the court was felt to be less important than the ability to perform the role to a high standard. However, for others, gender was felt to be a key aspect of their experience of the case.
All-female courts, I have never asked for an all-female court. My experience of all-female courts is that they are absolutely counterproductive, and it is because the assumption is that you have asked for something special, and therefore there is an assumption that somehow you're looking for an advantage that you shouldn't be entitled to. But I would also say that in my experience, the sorts of intrusive questioning you get about violent events that have happened to women are much more likely to happen with an all-female court, because the assumption is that because we're all women, we can actually ask you exactly what the man did and to repeat it, and so it is really trauma-inducing.
So even now, as I'm speaking, some of them still cannot face a male judge. However, they are prepared to say if they can get a male judge, but they say no, we want a female judge. Still, they cannot open up.
I've been through the process, and I was so desperate to tell my story that it does not really matter to me if it was, male and female judge together, fused together. I wouldn't say that. All I wanted to do was say my own bit, or this judge will really see this matter consider it the way it should be considered.
So what was actually going to happen on the day? And the kind of information that women found helpful was being told who would be present in the courtroom, what their role would be, and actually what the courtroom would look like. And this orientation process was really reinforced if a woman actually had the chance to visit the courtroom itself before the day of the hearing. So firstly, how these legal representatives and interpreters had facilitated their own understanding of the process was felt to be a really key part that underpinned women's experiences. For example, positive aspects of legal representation were underpinned by helping women to understand the actual processes of the court itself and what was happening on the day.
The other thing is that I think a recommendation should be prepare a guide. The interesting thing in this report is just how significant was the young woman's anxiety about what it was going to look like. To recommend that somebody prepares a decent visual guide that is accessible online, that people can see what a court looks like, what the front of the building is, the fact that you go into a reception area that is crowded with hundreds of people in most days.
And there have been some really useful guides in the past. I'm thinking of the little orange book for children's cases, and I think something like that would be a really, really good way to take this research forward.
There used to be a leaflet produced by the Tribunal about the appeals process and about the possibility of visiting a centre before an appeal hearing. Perhaps that could be reinstated if it doesn't exist anymore. That could be something that could be recommended. A small thing that Asylum Aid did that gave women information
because information is power. If you had known so many things when you went for your initial interview, you would have known what your rights are as a human being, and you know when things are not being done right.
I've been in nurse house for 1 year. Then the second, when you get in the second year, Yaswood, they took me to Yaswood. Since that time and now, 6 years, I've been destitute, no money. I'm jumping to the friends, sleeping. Only was helped me.
One of the things that struck me when you were talking about the kind of prevailing culture of disbelief and the way behaviour that we in this room understand to be a follow-on from trauma is interpreted as evidence that you're lying or that you lack credibility. All of this stuff is so familiar to any woman who has survived gender, sexual or domestic violence, even in a British context, and gone to the court for justice and for protection. Obviously with asylum cases there's a whole subset of issues, the kind of cultural ignorance there is doubled, if you like.
We're suggesting a review of the guidance note with a view to strengthening its value and use as a tool to enable best practice. It's not a code of conduct, but could it be, if it was richer and more specific to women, could it be helpful in guiding best practice? And we're recommending that that be looked at. Practical adjustments in the tribunal centres. So childcare is clearly an issue, and some people were saying a creche at the tribunal would be useful. Perhaps there are other ways it could be done with voluntary organisations and so on. Sufficient conference rooms to ensure privacy, and interpreters who have both the language ability and the sensitivity to deal with women's claims.
But what's very clear from the findings is that there's a lot of judges who recognise a certain good practice, which is then common to what legal reps think and common to what women think. And my hope is that as part of the advocacy, we'll be able to encourage some of those judges to share that good practice with other judges, to pass that on, to create that consistency that I think it was Katrina said is missing. But what the judges felt was good practice, which was about having an open attitude, an open mind, being sensitive to people, looking at the evidence in the round, was also what the legal reps saw as good practice, but it was also what the women themselves felt would benefit them and they would welcome. We're going to be already starting working on the advocacy before we even publish the report, talking to people, looking at ways in which we can make the sorts of changes that are in the recommendations, and we feel it's really good to have the research because it means we've got the evidence to back up our suggestions and our recommendations. And we also feel it's incredibly important to do that advocacy work, and I'm sure some of you will be involved with us in doing that, to ensure that women get a better deal when they go to their asylum appeals, and that they get a fair decision made, and that they're treated with dignity and respect.